Vail.
Mr. Chief Judge, and may it please the Court, I'm John Vail for the Plaintiff Appellant Kyle Coleman. I think we have a little bit odd situation here, so we've taken 15 minutes for my principal argument, reserved 10 for me for rebuttal, and then if there are issues regarding the cross appeal, Mr. Plaxton will rise during our rebuttal time to deal with those. So thank you very much for that. Your Honors, this Court created contributory negligence in the 19th century, and it's time for this Court to abandon it. The doctrine is not just, and this Court's failure to act will perpetuate injustice, and it would also send a signal to a divided legislature that this Court endorses the status quo. The opposition has invoked the constitutional power of the legislature over its ultimate power over the common law. And I think that misapprehends the role of this Court and the role of the legislature with regard to a common law question. Article 5 of the Declaration of Rights does give the legislature ultimate power over the common law, but it's a power to revise and amend. The Constitution envisions not just the substance of the common law, but the methods of the common law, that the common law be administered in the first instance by the courts. That power is in you, and you have emphasized that you are the guardians of the common law. This is not a statutory matter. This is a common law matter within the control of the Court, and this Court should act.
That the legislature has included either the words contributory negligence or principles of contributory negligence in its enactments in various places. Even if we were to agree, hypothetically, with your position that we should substitute some form of comparative fault for contributory negligence in the common law, wouldn't we be living under a bifurcated system infinitely, where you would have these statutes out there, assuming there was no further legislative response to the Court's decision, that would employ contributory negligence principles in certain kinds of actions? And we'd have that discarded body of common law would still have vitality in those cases.
That's true, Your Honor, but you do that now. You do that now when you apply the law of other states in transient causes of action that are tried in your courts. And it does not raise practical problems. You do not try these cases differently. You try them in very similar fashion. You use a different set of jury instructions and a different verdict form. But conceptually, you do this now. You try comparative negligence cases now in your courts, both in FELA actions, which are fairly common. FELA and Jones Act actions are fairly common in Maryland. And you do that, again, when you try transient causes of actions from, for example, the neighboring states of Delaware, West Virginia, and Pennsylvania. So I don't view that it's not a conceptual problem. And I can project with some confidence, I think, that it's not a practical problem.
When those cases that you suggest are tried in Maryland trial courts under a comparative negligence model, what model do they employ?
Well, the model we've called on, and the one that we believe is common, we've found numerous FELA cases. It is FELA, is the Federal Employee Liability Act cases. And that is a pure comparative negligence statute that recognizes joint and several liability, which is, as we talk about general joint and several liability, so that I don't have to preface each time I talk about it, let me emphasize now that there is no issue of joint and several liability in this case. This is a one-defendant case. You can decide this case and say only that we have done nothing to the doctrine of joint and several liability.
Wouldn't you think that would be thought irresponsible?
I think that poses a more difficult question for a common law court regarding opining prospectively on what doctrine might be. Now, what I've said, and as I said, it is not involved in this case, but we certainly briefed the question, and I'm happy to talk about it, because there's no necessary inconsistency between a comparative negligence regime and joint and several liability as you know it now, another common law doctrine.
If we do away with contributory negligence, does that necessarily mean we're also getting rid of assumption of the risk?
I think for negligence cases, and again, we have talked only about negligence cases. We have not talked about not raised any issues regarding strict liability cases, intentional torts, etc. We have talked quite purposely about comparative negligence. But the doctrine of assumption of the risk, the doctrine of assumption of the risk would disappear because it's an ameliorating doctrine, and the last clear chance doctrine also. So these are ameliorating doctrines.
If I follow your argument, that there would be no limitation in these types of cases if we employ comparative negligence.
Well, the limitation would be on the degree of negligence assigned by the jury to the plaintiff.
Well, that brings another question. In trying to see how this plays out, how would the jury apportion the damages? I mean, is there a standard that you're recommending that the jury should use in apportioning damages?
Well, again, I'd point to the FILA standard jury instruction, which is very simple. The Fourth Circuit doesn't have a pattern instruction, but the Seventh Circuit does. And it's very simple. It just says, instead of saying, do you find a defendant negligent, you ask, do you find the defendant negligent? Do you find the plaintiff negligent? If you find the plaintiff negligent, what percentage of fault do you assign to the plaintiff? And that's the only thing you need to do. And then it's a ministerial act to reduce the total liability by the percentage that's assigned to the plaintiff.
Take the facts of this case. A young man is hanging on the crossbar. The bar comes out of the ground and he's injured. How would the jury assign a percentage in this scenario? What factors do they take into consideration?
The same factors that they take into consideration in any negligence case, Your Honor, because now, effectively, the jury is apportioning negligence to the plaintiff in a contributory negligence case, because in order for the plaintiff to prevail, it has to assign contributory negligence of 0. There's a numerical equivalent to what the jury does in any contributory negligence case now.
I'm just trying to figure out how they do it. How do they do it in a case like this?
I think this is what juries do.
Oh.
Juries decide whether it is negligent, and juries can decide what percentage negligence. Your Honor, I know that in some ways that's an unsatisfactory answer, but I come back to my invocation of the methods of the common law. This is done in 46 states. It has been done over the last 50 years. It has not raised problems.
Can you tell me how they do it in one of the 46 states?
Exactly as I've described. The same as the FILA instruction. Exactly the same way.
Okay.
Can I take you back to the question that Judge Harrell raised, and then just to explore, I understand that there's but one defendant in this case, but we do have joint and several liability. We do have
yes, I believe my opponents have noted that. You're
right. And we do have a rich history under the Uniform Contribution Among Joint Tort Feasors Act, and the legislature has grappled with this. is it enough for this court to say, well, we don't have to address that because we only have one defendant? Because in many respects, that is an implication that is a serious one.
Oh, I think it's a huge implication, Your Honor. Again, why we treated it very seriously. Because I think even if this court did not opine on the issue, I believe it's my burden to make the court comfortable with the idea that it can be done, at least in some subsequent case or legislatively. Specifically with regard to UCATA, the Uniform Contribution to Tortfeasors Act, there is no inconsistency at all with what we are proposing here and with UCATA. UCATA presupposes a joint liability of the kind that you would have in a joint and several liability case. It presupposes that and deals with it. And I want to take you to Title 3B of UCATA is, I think, a key here. Its words, a joint tortfeasor has paid, it talks about, it invokes the common liability. So the only thing that would happen here is that there would be a change in the number of what the common liability is for purposes of UCATA. UCATA doesn't define the common liability. It presupposes the existence of a common liability.
And
it doesn't
changes the number. Yeah, that's where you're losing me. I understand it presumes a common liability, either by adjudication or by agreement. But when you say the number, are you factoring in then the plaintiff?
In other words, for purposes of UCATA, let's say this case, $100,000, all right? Let's say that there was a finding that the plaintiff was 20% contributorily negligent. Instead of the common liability for purposes of UCATA being $100,000, it would be $80,000 reduced by that 20% assignment of fault to the plaintiff. And after that, UCATA works in the same way it has always worked. There is no other effect on UCATA. And I say there's nothing inconsistent with the legislation because the legislation does not define what the common liability is. The legislation leaves the courts to define what the common liability is. So the statute still works in the way that it has always worked, with no impingement at all on any legislative value judgments that adhere in the passage of the statute.
So what you're saying is the plaintiff is factored into the concept of joint tortfeasor then? I mean, in the sense of he becomes one of many, if there are many.
The formulation we prefer is the formulation you see in Professor Landy's amicus brief. And I think because it's different, a plaintiff is not really a joint tortfeasor. Because remember, we're talking about negligence cases.
No, I understand that. But I mean, the concept of the act is he who, those that have wronged. And in some respects, you're including almost the plaintiff in that concept. And I want to be very specific that I'm not including the plaintiff in that concept, because we look at the plaintiff as being under a disability from payment. I think that's a better way to formulate it, because the plaintiff has not tortiously breached any duty to the public. The plaintiff has not caused damages to anyone other than the plaintiff when the plaintiff is assigned fault. That's qualitatively different from the position of tortfeasor. And I think that's an important distinction that you should hold in mind and maintain. And, Professor Landy's amicus brief explains this position. This is the majority academic position in this regard. We've alluded to Professor Wright's writings and Dean Wade especially.
Counsel, assume for the sake of discussion, the court agreed with your flagship premise. who or what would receive the benefit of that change of law? How would you write the prospectivity versus retrospectivity?
Well, you have different rules that you followed. You have a rule of applying a new rule to the case in question and to cases that accrue after the date of decision. You also have a rule regarding applying a new decision to cases, all cases that are pending and open at the time of decision.
Even if they haven't preserved this specific issue themselves?
I think preservation raises a different issue and perhaps speaks as a policy matter of invoking your line of cases that say to this case and to cases that accrue hereafter. And my time is up.
Thank you, sir. Mr. Willoughby?
I can still say good morning, Your Honor, and may it please the Court.
You can, yes.
I'm just looking at the clock up there. May it please the Court. I'm Wayne Willoughby. I'm here on behalf of the amicus for the petitioner, Professor Robert Land, who is the Venable law professor at the University of Baltimore School of Law. And I'm here to urge you to seize this opportunity to ameliorate a 165-year-old injustice in the common law of Maryland and adopt a pure comparative negligence standard, and to leave any collateral issues that we've been discussing for future determination on a case-by-case basis as those issues arise. And you have a concrete set of facts before you from which you can reach concrete conclusions. Now, there have been 12 states that have adopted comparative negligence by judicial action, and 9 of those 12 have chosen a pure comparative negligence standard. And it's pretty easy to understand why. It best achieves the primary goals of a tort system, those being compensation of the injured person, deterrence/accountability for wrongful conduct, and fundamental fairness and promotion of faith in the civil justice system. Now, why do I say that it best achieves? Obviously, this current situation where a plaintiff who is in any way contributory negligent, to use that term this time, is denied any and all recovery and receives no compensation. That affects not only the injured person, but in today's age, a plethora of secondary payers who may have either provided services, medical and hospital services to this injured person, or may have paid for those services. They go uncompensated as well, and the cost is spread to others. This doctrine, the doctrine of comparative negligence, however, doesn't visit the entire loss on the victim, the one who's least able to bear it, but in turn spreads that loss over the wrongdoers involved. And also, under the area of deterrence, the second major goal, we don't need a system such as comparative negligence as it exists, contributory negligence as it exists now to deter people from engaging in conduct that is harmful to themselves. As the Supreme Court of Michigan noted in the Kirby decision when it adopted pure comparative negligence, the deterrence is the prospect of mutilation. People don't need a deterrence at law to prevent themselves from engaging in conduct that's going to be harmful to themselves. However, we as a society do need a deterrent to prevent people from acting in a manner that is unsafe to other human beings. A pure comparative negligence standard effectuates that deterrence motive of our tort system because it will not allow someone, a tortfeasor who harms another, to be able to walk away, never held accountable for their conduct, never held responsible for paying for the damage they caused. Also, it makes fundamental sense and fundamental fairness. It meets fundamental fairness to engage in a comparative negligence fashion in dealing with injuries. It's fair and it's logical. And I've heard it said that Well, juries, they do rough justice anyway. What they do back in the jury room is they'll go and factor in that contributory negligence factor, and they'll just reduce a jury award on their own. That's what happens in the current system. But as the states of Illinois, Kentucky, and Florida all pointed out in addressing that argument for maintaining the status quo, there's something fundamentally wrong with the system that relies upon jurors to violate their oath as jurors to apply the law as given to them by the judge in order to obtain justice in the case. If jurors have to engage in a form of jury nullification in order to obtain a just result, there's something wrong with the law. And what that something wrong is denying a person any recovery whatsoever just because they contributed to their own fault or their own harm. Now, there are some states that look at a modified approach. Most of those states that have adopted modified comparative negligence, either a equal to or less than standard, or a 50% standard, or a 49% standard, they've done that as a result of legislative compromise, not as a result of judicial action. There is at least one state, Tennessee, that did it through the courts, and but there's something just inherently wrong with that because it doesn't ameliorate the harm of a comparative contributory negligence system by saying, well, the plaintiff has to be less culpable than the defendant in order to receive any recovery. All it does is it moves the bar from no negligence on the part of the plaintiff to some other arbitrary area or some other arbitrary level. That doesn't ameliorate the injustice that people who have harmed others get to walk away without ever being held accountable in any respect whatsoever for the harm they've caused. Moreover, as a practical matter, courts have noted that the 49%, 50%, 51% systems, the modified comparative negligence systems, have certain administrative problems, the most important of which is that it leads to more appeals, as plaintiffs who are denied any recovery whatsoever because a jury finds them less culpable than the defendant will want to go and take an appeal, or a defendant who believes that their culpability was so close to the plaintiffs they shouldn't have been held responsible, take an appeal. It's called the Wisconsin experience, I believe, because Wisconsin has modified, and they noted an increase in the number of appeals taken as a result of a change to a modified system. In a pure system, you won't see those appeals because the jury will work out justice, will work out the percentages, and that's that. There's no arbitrary threshold involved where, gosh, if I could have only proven 1% more, then I would have avoided liability, or if I'd only proven 1% more, I would have obtained a judgment. The stuff of which appeals...
It does put an extra burden on the jury, though.
Pardon me?
It does put an extra burden on the jury.
A modified system?
No. I'm talking about the pure one. The modified system.
The modified system does put an extra burden on the jury. They have to go and take out, okay, does this person cross a threshold or not?
They both would, wouldn't they?
No, not really, because the burden, if they're told, if the jury's informed of what the threshold is, it puts a burden because they know what the impact of their action is going to be and how important that's going to be to meting out justice. If they're not told of that, then they're not being informed of the importance of what it is they're doing. So it's a situation, Your Honor, where the only fair thing to do is to have a pure system where the jury doesn't have to be worried about thresholds. They simply have to be worried about making the determination, okay, how much of this incident is fairly attributable to the plaintiff's conduct, period.
I wonder, though, if you're talking about appealability, whether there's a greater number of appeals in a jurisdiction that went from a contributory negligence to a comparative negligence, whether it's pure or modified. I mean, in the sense that I have no idea how many appeals there are in our jurisdiction. I would vouchsafe it, probably less than there would be in a comparative negligence situation. But I don't know that. I don't know if there are any studies, since you brought this issue up, I wonder if there are any studies that address that.
I would have to go back and confer with Professor Landy on that, to be honest. I don't know of any studies that have looked at that per se. I have heard of the Wisconsin experience. It's mentioned in some articles. And I would think that initially there's going to be appellate issues as the court decides what do we do with joint and several, what do we do with assumption of the risk. I think everyone can agree that last clear chance makes no sense in the context of comparative negligence. Assumption of the risk is another issue altogether because that's more of a waiver in that you knowingly and voluntarily chose to encounter a danger, and that may take different analysis under the facts of a particular case. But in any event, the nature of the appeals that will happen if you make this a change will be working out the details so that you have specific cases before you and you can have them briefed in the context of facts as opposed to just arbitrarily and trying to dream up every set of factual circumstances. Whereas once you adopt, if you adopt a pure comparative negligence, you're not going to have to deal with appeals as to whether someone met an arbitrary threshold or not.
Thank you, sir.
Thank you, Your Honor.
Robin?
Good morning, Mr. Chief. Good morning, distinguished members of the bench. My name is Robert Zarbin, and I'm here on behalf of the Maryland Association for Justice, formerly known as the Maryland Trial Lawyers Association. First and foremost, I have to thank you. This is an extraordinary opportunity for us. I can't recall ever that the Court invited all the amici to actually participate in the oral argument.
It never happen again.
And I hope that's no reflection on me either. It's extraordinary, and we really feel like children on Christmas Day to have the opportunity to be here. I can't tell you. So thank you. Our role today as the trial lawyers is to assure you that this change to comparative negligence will be a very easy transition. And why? Because we're already trying these cases in Maryland courts. We're trying admiralty claims, we're trying FILA claims, we're trying choice of law claims every day. Moreover, our members of the bar already try these claims in the other 46 states that have adopted comparative negligence. And that's not to mention the largest law firms, which already have attorneys who practice in these comparative jurisdictions. Consequently, the Court already knows how to deal with comparative negligence, as do the members of the bar. So let's examine the practical implications of the change. First of all, trial judges' roles will be the same. In district court, the judge will remain as the finder of fact and law. These men and women are well equipped to assess the percentage of the plaintiff's negligence that caused or contributed to his or her own injuries, because that's what they're doing today. In circuit court, the judge retains the identical role. Nothing changes. And as for the litigants, it's the same parties, it's the same discovery rules, it's the same trial procedures. We have the same voir dire, the same openings, it's the same directs, the same cross-examinations, the same closings. We have the same amount of witnesses, and we're asking the same questions. Nothing changes. We're going to try our cases in the same manner we're trying them today. We will use the same jury instructions with just one new instruction that explains comparative negligence and one additional question on the verdict sheet, and here's an easy example. Was the defendant negligent? Yes or no. Was the plaintiff negligent? Yes or no. If yes, then express in terms of percent the degree of the plaintiff's negligence that caused or contributed to his or her own injuries. Now, Judge Green, you asked how are they going to come up with this number, and that's an excellent question, and I bet you hear that a lot from people when they stand here. But the fact is, it is. I can tell you that as a practicing member of the bar, I do a lot of workers' compensation claims. And one of the appeals that always comes up is whether the percentage of disability. The difference between being 49% disabled and 50% disabled under other cases, neck, back injury, for example, is double or triple the benefits, monetary benefits. So we ask juries every day, in what amount do you find the plaintiff disabled? And they have to come up with a number. They have the evidence from physician A, who may say 80%, physician B, who says 40%. They have to come up with a number, and they do. That's what they do, and that's what they'll do here.
And our standard of review of that would not change?
No, absolutely not.
But in those cases, a jury has the benefit of an expert opinion. In your ordinary multi-defendant case, the jury wouldn't have the benefit of an expert.
No, because no one can assess the degree of fault. That's what the jury's got to decide. But they do that today, Your Honor. They do it today. Aren't we asking the jury today, do you find the plaintiff 1% at fault? Do you find him 10% at fault? Do you find him 50% at fault? That's what we're asking them when we put the question of contributory negligence on the verdict sheet. We're asking them to do it, and this is our system of justice, and it works well in 46 other states.
What we're really saying is, do you find the plaintiff at fault, and they don't have to ascribe a percentage?
No, they do, because the fault has to actually contribute or cause their injury.
Well, yes, that's causation, but...
But they have to find at least 1%, yes. Otherwise,
yes.
Right?
Now, let's change your verdict sheet to a multi-defendant case.
Certainly.
Under joint and several liability. Would it not change? I mean, you're saying it would be just as facile? Based upon how would they then determine the comparability? You know, you have the plaintiff here, you have the defendants here.
Excellent question, Judge Battaglia, and the answer is, as Professor Landy's told us, it's a pure system, and we're going to use the disability model. So the only question the jury needs to ask is, what percent do you find that the plaintiff caused and contributed to his or her own harm, period. And the reason you don't need to break down the defendants in percentage is because there's only one indivisible injury. And the Uniform Contribution Among Tortfeasors Act tells us that they have to pay jointly or severally, and if there's any contribution, that's amongst themselves to work out. But you're right, you wouldn't have to ask them any question about, do you find defendant A how much, do you find defendant B how much, do you find defendant C? You don't have to ask that. In the disability model, all you have to ask is, did the plaintiff cause and contribute to his or her own injury? And remember, if the answer to that question is 0, then it's the same as it is today. So in short, both the defendant and the plaintiff will use the same procedures and trial tactics. There is nothing else we need to do. There's no retraining necessary. Judge Harrell, you too asked an excellent question about prospective. And the fact is that if a case is on appeal and you didn't preserve the issue of comparative negligence, you're out. Any case...
Is that necessarily so?
No, not necessarily
so.
So.
A choice that we have to make if we buy your flagship argument.
That is the choice the court is allowed to make. But certainly that is a very viable choice. But as far as all the other claims that haven't come to trial yet, absolutely, they should benefit from comparative negligence. In fact, I have a case coming to trial on Thursday, so I don't know how fast we could get the opinion out, but I certainly would appreciate it. If a special form is needed, we don't need to reinvent the wheel. These forms are already available in the 46 comparative jurisdictions as well as our federal courts. We can easily adopt whatever this court deems appropriate. We have an excellent rules committee with this court as well. Real-world implications. There will be the same amount of cases filed today as tomorrow if you adopt comparative negligence. How do we know this? We have the benefit of experience. Unlike Mississippi in 1910, we have 102 years of history and 46 other laboratories to examine when we debate the consequences of adopting comparative negligence. For example, the allegation of a change to comparative negligence leading to increased lawsuits has been refuted by empirical evidence. In Kirby versus Lawson, the issue before the Michigan Supreme Court was whether state law should shift from contributory negligence to comparative negligence by judicial decision. One factor of significance was the potential impact on the dockets of a switch to comparative negligence. In an appendix to its opinion, the court looked closely at the results of 2 field studies reporting on the impact of the adoption of comparative negligence in Arkansas. One study was done by the Columbia Project shortly after Arkansas had shifted to comparative negligence in 1957. 10 years later, the Arkansas Law Review replicated the study using the same form of questionnaire and obtained virtually identical results. Using the Arkansas studies, the Supreme Court of Michigan reported that it was satisfied that the impact of shifting to comparative negligence had not been to overwhelm the courts in that state, and that it expected no different effect in Michigan. As a result, the court felt free to adopt the comparative negligence rule on substantive grounds. Neither Michigan nor Arkansas has ever gone back to contributory negligence, nor have any of the other 44 comparative jurisdictions. Speaking for the Supreme Court, Mr. Justice Stewart addressed this issue in United States versus Reliable Transfer, when he said, "Experience with comparative negligence in the personal injury area teaches that a rule of fairness in court will produce fair out-of-court settlements. And to continue the operation of an archaic rule of contributory negligence because some believe its facile application of out-of-court yields quick, though inequitable settlements and relieves the court of some litigation is not sufficient reason to reject comparative negligence. Congestion in the courts cannot justify a legal rule that produces unjust results in litigation simply to encourage speedy out-of-court settlements." Again, practically speaking, the adoption of comparative negligence should encourage more resolution to conflict because the defendants will not be holding out for the chance that they might be able to persuade the judge or jury of 1% is at fault. In other words, there will be fewer attempts at jackpot justice because more cases will be resolved. For these reasons, we ask that you find that comparative negligence is the established doctrine now.
Thank you, sir.
Thank you.
Mr. Weiser.
Thank you, Your Honor. Good morning. My name is Douglas Feasor. Matt Lalomio is my co-counsel. We represent the Soccer Association of Columbia, or SAC. It is not necessary that this court decide the issue of contributory negligence in this case. SAC is entitled to a decision in its favor as it did not owe Mr. Coleman a duty to protect him from this accident. This accident occurred on August 19th of 2008 at the Lime Kiln Middle School. It's a public school owned by the Howard County Board of Education. Mr. Coleman was 20 years old at the time, 1 month short of his 21st birthday. He volunteered to help coach one of SAC's 11 and under recreational soccer teams. SAC, like many recreational programs, does not have enough fields of its own. So it uses the public school fields for its games, practices, etc. On the day of the accident, the volunteer parents who were coaching the team had arrived at the Lime Kiln Middle School. And as in many recreational programs, as you may know, it's kind of squatters' rights. Whoever gets there first can select the area that they want to practice in. They selected the center field, left field area of the baseball diamond, and they put up their cones to designate their practice area. And the coaches brought with them the goals that they were going to use for practice. They're these little pug goals. They're about, when they're unfolded, they're about 3 feet high, 4 feet wide. They stuff in a bag. The coaches carry them. And they brought those goals with them that day to use. As the team was getting ready for the practice, one of the volunteer moms was out in center field giving out jerseys to the children. Practice hadn't started in earnest. Mr. Coleman came, and before practice started, he went over on his own, over into the right field area. And in that area, hard on the right field outfield line, sat an unnetted goal that was there at the time the SAC coaches arrived. And Mr. Coleman decided that he was going to shoot a ball on the goal, which he did 1 or 3 times. One of the balls that he kicked, the last one, went through the goal, over the sidewalk that was just behind the goal, and into the field that was adjacent to the area. Coleman goes and runs and gets the ball, and on his way back, he jumps up on the crossbar, swings on it, and the crossbar comes down and strikes him in the face. He suffered a fracture to his orbit. He was treated in the hospital where it was determined, and he admitted that he had been smoking marijuana that day. Mr. Coleman, at the time of the trial, his eye had healed. He had no neurological damage, and the only sequelae he had was some slight numbness that today may not be there at all.
But one of the briefs said he had titanium plates put in his...
He did. He had a plate put in his orbit, but he sees fine. There's no other neurological damage other than the slight numbness.
It apparently was never determined who owned the goal?
No, we could never determine who owned the goal. That unnetted, unused goal on the right field line was there when the parents got there. This was early in the fall season. It may have been there. There was a high school across the street. The high school may have used it, but in any event, we did some discovery. We couldn't determine who owned it. We know one fact. SAC did not own it. SAC did not bring that goal. SAC was not going to use that goal on this practice.
If the standard is comparative negligence, you would obviously be in a position to argue to the jury that Mr. Coleman was 90% or more responsible for this accident, correct?
That's correct, Your Honor. We could argue that, but under the argument that we make presently, there's no duty, legal duty.
I understand.
Yes.
I understand that.
But yes, the answer...
If the law changed, you'd be able to make that argument, and then there could be this sense of fairness based upon the jury's evaluation of all the evidence.
Your Honor, there's no sense of unfairness in this case. Here we have a 20-year-old man who volunteered. He was the adult supervision. He comes to the practice high on marijuana and decides to swing on an unnetted goal. This is not a piece of gym equipment. It's not a chin-up bar. He misused this piece of equipment. There is no sense of fairness using contributory negligence in this case.
Do we know from the record in this case, was the unnetted goal, was it sitting in a metal sleeve in the ground, or was it just...
The goal disappeared, so no one had a real chance to inspect the goal. But the description given of this goal was that it was not a permanent goal with the bars in the ground.
Was something that sat on the ground?
Yes. If you look at the goals now that are generally used around, they're kind of a curved configuration and go back, and they're portable. They can be dragged around, and so they're generally not, and we believe this one was not one of the portable goals that's drilled or anchored into the ground itself.
Did it have a twin on the left field line?
There was conflicting testimony as to, no, there was not a twin on the other line. If you go to the left field line extended from the baseball diamond, that's where the team was, the 11 and under team, with their cones set around and their portable goals. That's where the practice area actually was, the center left field area, and there was no permanent or portable.
There's just this one unnetted, I'll call it otherwise regulation goal, sitting on the right field.
Sitting on the right
baseball field at a middle school?
It's a middle school, Limekiln Middle School. And so it was sitting there, and that's the goal in question. And so we argue in this case that there was no duty for SAC to do anything with respect to Coleman and this goal. An analogous case that the court has decided is the case of Patton versus U.S. Rugby Football, where during a rugby tournament, a rugby player was playing a game. His father was in the stand, and there was a thunderstorm with lightning snapping all around. And as the father was struck by lightning and killed, and his son, who was a player, was injured. And so the question was, what duty, if any, did the soccer organization, who was a defendant, and the referees have to call the game? And the court decided and discussed, what is it that we have to find to establish a legal duty to someone else? And in that case, they discussed the various considerations, including foreseeability of the type of harm that occurred, the moral blame, the consequences to the community, and the relationship between the parties. And of course there, with the facts of that case where the lightning is snapping over their heads, you could argue that it's foreseeable. there. But the court said, no, that is a consideration, but it's not one of the most important consideration. The relationship between the parties really is. The special relationships that the court has found in order to establish duties. And those special relationships have been found to be common carriers, innkeepers, possessors of land, or some dependency upon the defendant where the plaintiff cedes control over his actions so that there's an element of reliance. None of that is here. This is a almost 21-year-old man who had experience. He lived on his own. He worked full-time. He was a student at the Howard County Community College. He drove his car, and he only came to practices and games on occasion.
But he was, when you say that, the difference in the Coleman case was the father was truly a bystander, and we were talking about the duty to the world because it could have been anybody.
But
this individual, as I understand it, to take the Patton case a step further in this case, this individual was somehow associated with SAC.
But Patton, Your Honor, too, one of the plaintiffs was the son who was a player.
No, but he was an adult player who ostensibly, it wasn't an in parens patria situation, and that's how, as I understand it, Patton was argued. I mean, that he was an adult player, he could have made the choice and all of that.
Right.
Now, all I'm asking is, there was some relationship between this young man and SAC.
He was a volunteer. He was a volunteer assistant coach.
And they accepted him as a volunteer. So there's some differentiation between the parties. I don't know whether it makes much of a difference in terms of the duty, but there is a difference.
There's a slight difference, but there's no cases exactly on four with this one. The Patton case is as close as it gets in Maryland, and the court said, quote, our decision is consistent with our view of narrowly construing the, quote, special relationships so as not to impose broad liability for every group activity. As well, Coleman, in one of his briefs, argued that premises liability applies, but in fact that was not raised, or it was raised, it was not preserved for appeal. Coleman asked for a premises liability instruction. It was not given by the court, and no exception was made to it. So premises liability has nothing to do with this case. There are other duty cases that are instructive as well. There's the pharmaceutical case, Upjohn case, where they found no duty to an employee's spouse when they tested the spouse for HIV. The spouse, his spouse got HIV, no duty there. There's the case of Coates versus Southern Maryland Electric, where poles were put very close to the road in positions where people could strike them, and again, no duty was found. And so in this case, because, one, SAC didn't control the property, the goal wasn't theirs, they didn't bring it, they didn't intend to use it, and it was not in their area of play. They had no duty with respect to Mr. Coleman, just as if they had no duty to tell him that there were potholes on the walkway or to do other things to protect him. He was an adult that could have come and gone as he pleased at that time. Your Honor, if I may, too, now address the contributory negligence issue before I get to my other issues on cross-appeal, which also are important. Contributory negligence has been a pillar of the tort law here in Maryland since 1847. Contributory negligence has been reaffirmed in the case of Harrison versus Montgomery County Board of Education in 1983, where this court considered and rejected all of the very same arguments for change that are raised here today. If you look at that case, the issues there jump out at you as the same issues that we face today. As well, from 1966 to 1982, up to the court's decision in Harrison, the General Assembly had considered and rejected 21 bills seeking to change from contributory negligence to comparative negligence. In discussing the legislative history, Judge Murphy, speaking for this court, stated, quote, however, in considering whether a long-established common law rule unchanged by the legislature, and thus reflective of this state's public policy, is unsound in the circumstances of modern life, we always recognize the Declaration of Public Policy of Maryland is normally the function of the General Assembly. Since that holding in Harrison, the General Assembly has rejected at least 15 additional bills to change the comparative fault, the latest being in 2007. The rule of stare decisis requires that contributory negligence remain the law in Maryland. Stare decisis is the policy where courts follow past decisions, even though if considered for the first time, the court might reach a different conclusion. Of course, the rationale for stare decisis is the need for stability, predictability, and integrity in our law. It is important that our country and state be seen as governed by laws and not by men. We confirm this doctrine of stare decisis each and every time the court decides a case with contributory negligence, which it has done many times, including in 2011. In Harrison, this court said, quote, "For reasons of certainty and stability, changes in decisional doctrine are left to the legislature." The court has followed stare decisis and used judicial restraint on many occasions and has declined to change well-settled laws in disputes which were fiercely opposed, as this one. These include, just by example, dram shop liability, attractive nuisance, the boulevard rule, the rule of lex loci delicti, and parent-child immunity, among others. Further, there hasn't been any changes since Harrison that would justify the change from contributory negligence to comparative negligence. This court in Harrison recognizes that change in the common law and stare decisis could be made if the court found, quote, "In light of changed conditions or increased knowledge, that the rule has become unsound in the circumstances of modern life, a vestige of the past, no longer suitable to our people." In 1983, when Harrison was decided, the court was looking back to 1847 and finding no change. And that from a time when contributory negligence was adopted, there were only 30 states. From 1847 to Harrison, we had the Civil War, World War I, Prohibition, the New Deal, school desegregation, World War II, the Civil Rights Act, Vietnam, all these things happening, and the court said there hasn't been enough change in our society to justify going back or changing the law. Since Harrison, no changes have occurred in our society, making contributory negligence unsuitable to our modern life. The facts of this case speak to that clearly. What's unsuitable about contributory negligence denying Mr. Coleman, 20-year-old adult, coming to a practice high on marijuana and jumping on an unnetted, unused goal? It's not fair, and it's not unsuitable.
States since Harrison have changed over by either legislation or judicial decisions.
Your Honor, I don't recall the exact number off the top of my head, but at the break I will get that because I do have that somewhere.
You know, when you remarked about parent-child immunity, I recalled and confirmed with the Chief Judge that we did abrogate interspousal immunity.
We did.
And there was, and so there at least some sense that
yes, no changes can be made, but that one was well deserved. I mean, that interspousal immunity came from the vestige of a wife as a chattel, and with all the laws that we've had and the progress that we've made, that was ripe for change. But that isn't this case.
But there haven't been. I mean, it's clear that it was with the concept of the woman as chattel, which we've disputed in many, many circumstances. But I wonder, in light of your discussion about societal change, whether it was because of societal change or whether it's because the court thought that it was appropriate that we make the change. I'm trying to plumb that because I understand your argument, but I don't know whether that applies to what we did in interspousal immunity.
Well, Your Honor, with the Equal Rights Amendment, I mean, there clearly was a societal change in women's standing as equals, and so that decision was based on that. You haven't seen that kind of thing in personal injury cases, though, and that's why this case is different. The court in Harrison said in cases such as this, we have to defer to the legislature. Quote, whether to abandon the doctrine of contributory negligence in favor of comparative negligence involves fundamental and basic public policy considerations, which is properly addressed by the legislature. The legislature is equipped to consider and weigh all the conflicting policies. You had some questions and discussions on what comparative negligence are we going to adopt, if any? Pure, less than 1/2, equal or less than 1/2, or the slight gross. The states are all over the place. There's 14 states that are pure, 14 less than half, 17 equal, and South Dakota is the slight gross. So these all have major policy implications which the legislature can address. That's what they're geared up to do. They can take testimony. They can hear from expert witnesses. They can explore each of the other states that have gone there to see what their experience is. This court doesn't have the resources to conduct those kinds of investigation and see what real empirical evidence there is with regard to the history that those other states have, the costs involved, and the implications on their tort liability.
The courts, the courts that have adopted comparative negligence, judicially adopted, the states that have done so, has it always been pure comparative negligence, or has any court attempted to do a modified form of it judicially?
Oh, I think most of the comparative, and I don't know what the exact number is, almost all of the comparative negligence have been adopted by statute.
Maybe you better go to your cross.
I'm sorry?
You said you wanted to get to your cross petition?
Yes, Your Honor. If I may say that for my rebuttal.
Well, it's good. Well, you can. I don't care if they don't mind. That's fine. Normally, you have to at least introduce it so that they get a chance to shoot.
Your Honor, and I will do that. The most egregious thing that happened here, there was a finding of primary negligence, or we wouldn't even be discussing the contributory negligence. There was a subsequent handbook that was issued by SAC as a direct result of this incident that then instructed all of its coaches, when you go onto a public field, make sure you look at the goals and secure the goals. It was in direct response to Mr. Coleman's accident. Before that, handbook hadn't addressed it at all. It was clearly a violation of Rule 5407. The judge recognized that at trial, but did not do anything about it. And I will address the other issue on rebuttal.
Was it the policy, though, before and then simply reflected in the handbook later?
It was not. Mr. Carlin, the executive director, stated that his policy was with regard to their own fields that they own, not off-site fields. Thank you, Your Honor.
Thank you, sir. Mr. Faginski?
As the one who asked for oral argument and got a very tiny little bit, I apologize to the court for the whole simus here.
Oh, no, please.
But let me say this. After listening to this, I'm glad I'm here because there's some things which you have to know that are not exactly what you've been told. Number one, if you establish comparative negligence and you don't do something about UCADA, you're going to have the following situation. You're going to have a gigantic problem. Because if you establish comparative negligence, you just don't decide in a multi-defendant case what the comparison was between the plaintiff and one defendant, but what the comparison is between all of the plaintiffs and all of the defendants. And then you're going to completely uproot UCADA because UCADA says joint liability, not several liability. You have joint liability, you adopted it. The Maryland Court of Appeals adopted it in 1941, and it had an opportunity when it adopted joint and several to take the alternative position And the alternative position was to just apportion the defendants, apportion their liability. That was on the table. That was the uniform law's approach. They gave you two choices, and the General Assembly chose joint and several. Now, joint and several is a great issue, but it only arises where you have multiple defendants. And what they're talking about here is a situation where you're talking about a single defendant and a single plaintiff. But you're going to have a ripple effect. You're going to have a ripple effect, and that's why we asked to come here and talk to you, because we have 27,000 cases in the asbestos field where we have numerous plaintiffs and numerous defendants.
Mr. Figinski, would it ever arise when you have what's sometimes referred to as an innocent plaintiff and then multi-defendants?
Sure, it happens a number of times with respect to our asbestos case.
You could have one defendant that's bankrupt and a couple other defendants.
That's the bane of our existence. That's the bane of our existence, and it's a salvation of our ability to give some recovery for our plaintiffs. Because there's one wrong. Our people got sick for a number of different places that used the rotten stuff. Then you take out, well, we'll give you $1,000, Mr. Dead Person, or your estate, but you only get $75 because the guy who was three-quarters liable, he went bankrupt. On page 22 of your Rules Committee report, it is stated that under Maryland's current system, the extent to which a claimant may recover in multiple defendant cases is largely controlled by UCADA. We didn't write it. Your committee wrote it. And if you change the rule, for single defendants, you're going to either directly or by implication raise the issue for multiple defendants and multiple plaintiffs. That's not before you. It is an issue which is incredibly intertwined, and that's why a legislative solution is right for this particular issue. Now, the question came up, how many states adopted this by legislation and by statute? Now, that's also in your Rules Committee exegesis. And if I can read my own handwriting, I'll probably be able to tell you. On page 25, I think it is, only 10 of the 46 that abolished joint and several revised any other part of the law. 33 states that adopted comparative negligence, 33 did it by legislation, not by judicial fiat. Now,
which means 13 did.
That's the way I would do my even my bad mathematics would allow me to get to that, Your Honor. Nobody has mentioned what the two amici argued in their one part of their brief. These amici over here. They said that because one bill, House Bill 1129, a couple of sessions ago, failed, you should give some credence to that. House Bill 1129 was a bill that would have adopted by legislation contributory negligence for Maryland. You don't have to. In the case of, in the 2011 case of Locklear versus Smeltz-Smecker, Judge Harrell's opinion. Simster. Well, I see I can't read my own writing. Collateral source rule case. Long-standing principles of the common law do not need statutory affirmation, and that's a good reason why that bill failed.
Before we let Mr. Figinski.
You're gonna, I got all these lights here.
No,
This is my time
it's his time.
In your brief, as I recall, you have, I won't, well, you correct me, but I call them fallback positions, where you get into the issue of prospectivity versus retrospectivity of application if the court were to go to comparative negligence in one form or another. How does that ameliorate your primary concern about the effect on the 27,000 asbestos claims?
Because those cases would proceed and stay. I got a two-part answer to that. Actually, a three-part, if I may. First, those cases, in my prospective overruling, would proceed as they would have in the past. They would be governed by the rules of UCATA. They would be governed unless the legislature changed it. And the legislature changed it. It usually goes forward, doesn't go backwards. And they would be governed by contributory negligence, number one. Number two is that there is the Stearman case, Stearman versus State Farm, 381 Maryland. All you have to do is turn one page to get this result. And that is that on page 453, this court wrote through Judge Green that that when you're dealing with the changes in doctrine, it's okay to do that by your decisional process. But then you go to 450, you turn the page, you go to 454, and what you say is that the public policy in that case is not. It's a statute. It's not common law. UCATA is a statute. It was done by specific statutory adoption, and what you're going to do is going to affect that. And you don't do that by your decision. And finally, prospective overruling is not something that dropped out of the sky in Linkletter versus Walker by the Supreme Court of the United States in some criminal case. It was spoken to the New York City Bar Association by none other than Mr. Justice Cardozo in his annual lecture to them. And in the Sunburst case in the Supreme Court in 1938 said there's no constitutional right to retroactivity, and that is the law today. And I just want, Mr. Udemol is the author of that great brief that you've made allusions to, Your Honor. I did very little on that, and I'm sorry if I pounded the table and made too much noise. It's just the way I do things.
Mr. Duval.
Good afternoon. Maryland tort law is a tapestry of common law and statutes woven around two central cores. One of those is that the harm caused by all contributing faults is indivisible. And the other central core is that faultless plaintiffs should be made whole. This petition is about swapping out those two central strands of our tort law, and the wisdom of doing so depends on what happens, in part, to the other strands in that tapestry. To recap the brief of the Maryland Defense Counsel, some of those strands are joint and several liability, the Contribution Act, and a number of statutes which recognize the defense of contributory negligence. The case before you calls on the Court's keenest sense of jurisprudence, not simply in correctly discerning substantive law, but in discerning this Court's proper place in constitutionally divided government. Precedent was established in 1847. In the last 45 years, the General Assembly has rejected about 36 bills which would change the common law of contributory negligence. The General Assembly's determination of public policy could not be more clear. Contributory negligence is and should be the law of Maryland. Thus, the petitioner fundamentally asked this court to second-guess the wisdom of the General Assembly. Our system of divided government is...
Why is that necessarily the only inference that can be drawn from the inaction of the legislature over that period of time?
Because it's not inaction, Your Honor. Because it's not inaction. And I've been down there 10 or 15 years on this. A proposition is put before them, they hear it, they decide not to change the law.
They're fiercely lobbied by all camps that fight to a standstill.
Well, that's true, but if they felt that...
Why isn't it just as logical an inference that what comes from all of this, or should be taken from all of this, is that, well, we're not going to change what the court did these many years ago. Let the court do it.
Because that assumes, Your Honor, that in order for the General Assembly to maintain the status quo of common law, which it presumably knows, and in this case certainly does, they have to codify that common law. All they have to do, and what they have consistently done, is say, the law is good. We are not going to change the law. We don't change the law. Otherwise, you are second-guessing their wisdom. It is what they have done. One reason that this decision is really not best addressed here is the humility of common law lawmaking, which decides particular disputes before the court as distinct from the plenary problem-solving of the General Assembly. Now, I've had the pleasure of being here several times to argue about what the common law is, and as I said before, I have frequently been to the General Assembly to discuss there what statutes should be concerning tort liability. And the distinction in process in the two places could not be greater. The General Assembly is set up to consider problems, decide plenary solutions. If we're going to start dividing up the harm of contributing causes, how are we going to divide it up? It's going to be pure, it's going to be comparative. What are we going to do with joint and several? How are we going to do with the contribution? What are we going to do with the Contribution Act? What are we going to do with all those statutes we passed that say we recognize that contributory negligence is the law of Maryland? And they have done that on all the occasions cited in our brief. The petitioner states that you can simply pull out that central thread of tort law and avert your gaze from the attendant implications which this court aptly described in the Harrison decision. It is prudent for the court to constrain itself to the case before it, but it is not prudent to pretend that doing so will not shred that weave of laws, and it is not prudent to pretend that this will not result in an extended period of uncertainty while that weave is rebuilt through a painstaking process of years where litigants won't know what the Maryland law is and will have to guess at that law and have to bring it here for follow-up decision-making on your part as you do common law lawmaking. And moreover, the judicial process cannot revise the statutes passed by the General Assembly. So the answer to the petition is clear. The General Assembly has resolved Maryland's public policy regarding contributory negligence. Disliking the work of the General Assembly is not an adequate reason to ignore what it has done. Thank you.
Thank you. Ms. Kruger.
Good afternoon. Thank you for the opportunity to address the Court on behalf of state and local governments with respect to this question of contributory negligence. My clients are the local government insurance trust, the municipalities and counties of the state of Maryland. And although I don't have today the state as my client, I will address the implications for the state because the government, not being a party to this case, does have a keen interest in the preservation of the contributory negligence defense. If that defense is to be changed, it should be done by the General Assembly, and let me explain why. As the Court well knows, the State itself can only be sued by its own consent. And that consent can only be given by the General Assembly as it has given it under the Maryland Tort Claims Act. The Maryland Tort Claims Act, a carefully crafted statute with certain notice requirements, certain parameters on damages that are available, and other procedural regulations that the General Assembly considered. Similarly, with the Local Government Tort Claims Act, the General Assembly has directed local governments to indemnify its employees for their negligence. Again, a carefully crafted statute balancing the needs to protect the government treasury against the desire to compensate persons who have been injured by government employees. But the waiver of sovereign immunity and this sort of mandate that local governments indemnify their employees is not a small matter. This is something undertaken by the General Assembly under very careful circumstances and considerations. And one of those considerations was the existence of common law defenses that would be available to the government during litigation. One of those defenses, of course, is that of contributory negligence. The State Treasurer's Office regulations, the internal workings of local governments that are self-insured, the procedures of the local government insurance trusts in insuring the smaller municipalities are all based on this, to use Mr. Duvall's example, tapestry of both how the statutes are crafted and the backdrop of Maryland law that includes the defense of contributory negligence. Judicial abrogation of this defense will, as he said, unravel that underpinning that supports the statutes that establish the right to sue the government in the first instance. So, for example, if contributory negligence had not been available as part of the common law to defend, for governments to defend themselves, the General Assembly might have crafted the Local Government Tort Claims Act differently. It might have codified contributory negligence for the use by governments as Indiana did. That type of action can only be done by the legislature. The court is not in a position to make that kind of carving out as public policy might dictate.
Wouldn't that naturally follow then? That in whatever the next legislative session may be following the court's opinion, if it were to agree with Coleman,
then make adjustments.
Would be to revisit the risk management or the underwriting assumptions that have been tweaked or upset and decide what appropriate response be made.
I suspected that the court might ask that question, and in thinking about it, I thought immediately of our very recent experience in the case of Solsky versus Tracy, I think the case was called, where there was an attempted legislative response.
We could go all day today without listening to that.
I'd hate to see the local governments put in the position of having to fight that battle and incur the expense that goes along with that sort of, and it sort of illustrates why this type of thing is better dealt by the legislature.
But in other jurisdictions that have adopted comparative negligence judicially, this must have been an implication for those jurisdictions also. I mean, ostensibly, we're not the only state that finds ourselves in this bubble. So do you have any indication about what happened in the other jurisdictions that adopted comparative, whether it's pure or modified, in terms of the implication for state or local governments and local governments?
Well, I don't have a specific answer to your question, Your Honor, although what still comes to mind for me, and I was struck by it when I found it, was that this choice in Indiana to specifically carve out certain types of claims that still carry with them contributory negligence as a defense, that is, claims against the government, and I think also medical malpractice claims. So if we start to go down this road, we can see that there are these very diverse aspects that, again, to echo my colleagues, really seems to be best dealt with the legislature. Thank you.
Thank you. Mr. Taberzi.
Chief Judge Bell, Your Honors, it's an honor to be here today. My name is Paul Taberzi. Thank you for hearing from me. I appreciate it. I'm here testifying and presenting on behalf of my...
Testifying, are you?
Spent too much time in the General Assembly, Your Honor, testifying. I'm arguing, presenting as a friend of the court, and it's an honor to be a friend of this court, on behalf of the Maryland Chamber of Commerce and a coalition of large Maryland employers, hospitals across the state, large employers, which together, by my reckoning, provide most of the private jobs in the state of Maryland. And they care deeply about the civil liability system in Maryland, and so we filed the friend of the court brief, and we're delighted that you're hearing from us. Some of them use contributory negligence, some of them don't. But all of them care deeply about the balance and the structure that we have in our civil liability system. And if Your Honors were to reject contributory negligence, you would also then have to deal with all the other ancillary doctrines that we've heard about today, and I would submit there would be years of litigation.
Not necessarily in this opinion.
No, sir. You're right, Judge Harrell. Not in this opinion, but you would set into
balance. What is it prudent to go beyond what is necessary in deciding this case? How far do you go beyond that in considered dicta?
When I read the record, to be honest, I think Mr. Feasor makes the case that you could simply affirm on the facts and not reach this cosmic question, and that's really what you ought to do. But if you were to reject contributory negligence, we would have years of controversy, we'd have years of lawyers arguing. Lawyers love it. It'd be great for me and my brothers and sisters. But it would be terrible for employers in the state, and I would submit for everyone else. Why do we need that? Your Honors, there's been no hue and cry to do comparative negligence. There's no blue ribbon commissions begging you to do this. The Bar Association is not here today. They're not shy. Why have they not filed an amicus brief asking you to do this? There's been no press articles about bad cases. And just last Halloween, Judge Green wrote a unanimous opinion for the court applying contributory negligence 10 months ago. Thomas v. Pankow Management, Judge Green wrote the opinion, very good opinion, that talked about assumption of risk and contributory negligence. Unanimous opinion. Judge McDonald wasn't on that case, but everyone else was. This court applied contributory negligence without any question. That was only 10 months ago. That was actually also issued after Judge...
The reason why we would have in that case was because it hadn't been queued up, and it is queued up here. I mean, it wasn't, you can't use that case as a reaffirmation of contributory negligence because there weren't jury instructions, as in this case, where a comparative was presented. This case has been queued up in terms of Harrison for that consideration. So there's a difference.
Well, perhaps, but I'd respectfully say if there was some reason to make the change, Judge Green might have addressed it, Your Honors might have addressed it. You also issued opinions.
We would have had the bar complaining about our addressing an issue that wasn't presented.
But contributory negligence was in that case, Mr. Chief Judge. It was. It could have been addressed. But I would submit to you, nothing has changed. There's no outcry. There's no hue and cry to do this.
But our real focus on those, and there was a second case was with that, our real focus was the black ice issue.
Right. Yes, sir.
So that's what that was all about.
And what my clients care about, and my general counsel clients are really going to be concerned when they heard my brother who said this morning, not only do they want you to throw out contributory negligence, but I think he said assumption of risk would disappear as well. That would be a profound and radical change in Maryland tort law. And there's no reason to do that. Pardon me, Judge Raker.
Lawyers would be settling cases if this court went to comparative negligence but didn't really opine on any of the other issues?
Judge Raker, no. I think there will be years of chaos and litigation until we sort this out. And that's why I will say, as someone who does spend a lot of time before the General Assembly testifying, Mr. Chief Judge, it is better for the General Assembly to deal with this. They could adopt one bill after a lot of back and forth, a lot of consideration, subcommittee, committee, two houses, and deal with all these issues in a systemic way. And I would submit to you, give them a chance to do so. They might do it. They've not taken up the issue this term, and that's the better way to do it versus changing one aspect. It's as I say in the brief, throwing a rock in the pond of Maryland's tort system which would then lead to years of argument and confusion and needless expense. So on behalf of the state's employers, we'd ask you, affirm, don't even get into this, and leave it up to the General Assembly to deal with this issue. I do thank you for hearing from me. It's an honor as always. Thank you.
Thank you, sir. Mr. Vail?
Your Honor, while he's doing that, I'm going to pick up something that I dropped, if you don't mind.
Please, please.
There you go.
Thanks. Okay.
Thank you, Your Honor. I'm going to take my limited time here and belie my New Jersey roots and speak quickly. With regard first to Mr. Feasor, one of the things he said is there is no unfairness here. Is it really? You got a kid jumping up onto a soccer goal, $100,000 worth of damages, he's going to get nothing when the jury found that the other side was negligent. That strikes me as unfair. Let me point to two other cases from your case law that I think are illustrations of this. You have two cases from the Court of Special Appeals. The Sapinari case, the case that involved a woman who went every day to the Laurel train station and crossed over, one day was crossing over a walkway that crosses the tracks. It's there, provided for that purpose. She's used to doing this. She's doing it every day. She listened, slowed down. It was a question of whether she actually stopped, was walking slowly, and was hit and killed by a freight train coming through the suburban station at 52 miles an hour that did not sound its horn as it was required to do. She was found contributory negligent as a matter of law. Another case, an older case, is Johnson v. Dortch, which involves the vaunted Boulevard rule. But this is at nighttime. A person stops at a stop sign, turns right, and is hit by a drunk driver who is speeding without his lights on. The plaintiff was found contributory negligent as a matter of law. I think there's a matter of unfairness here. Mr. Feasor also said contributory negligence has been a pillar of the jurisprudence since 1847. I've talked about the role of the common law. I want to go to one of the champions of the common law, Justice Holmes, to rebut this. In a Harvard Law Review article, he said, "It's revolting to have no better reason for a rule of law than that it was laid down in the time of Henry IV. It is still more revolting," and this piece of the quotation is germane, especially germane here, "if the grounds upon which it was laid down have vanished long since, and the rule simply persists from blind imitation of the past." That's contributory negligence in Maryland. It arose at a time when you tried to subsidize industries. It arose at a time when there was no insurance. It doesn't work now. It's unjust now, and it needs to go. Noted Harrison. Harrison is, of course, a problematic case, and noted that the legislature had rejected 21 bills. 3 months after you decided Harrison, you decided Boblitz, in which the legislature had rejected 7 bills that would have done what you did do in Boblitz. And 20 years later, in Bozeman, you went the rest of the way on interspousal immunity, noting that one of your considerations for changing a rule of common law was a consensus among your sister states. And notably, pure happenstance here, I didn't make this up, you noted that the consistency you had there was 46 other states had done the same thing.
Is that right?
We're asked a question about other changes since Harrison. I could not pull up the states that have changed legislatively since Harrison. The states that have changed judicially, Your Honor, are Tennessee, Kentucky, Missouri, and South Carolina. Turning to the Angelos Law Firm presentation, and invoking the Rule 22 of your Rules Committee report, that you could have an issue with judicially determined shares of fault, not in the model that we have proposed for you, given the colloquy I had with Justice Battaglia about the idea of the common liability under UCATA. Pure comparative negligence does nothing to upset any either common law or statutory contribution scheme. Nothing. It's completely consistent. The Maryland Defense Council says that we should maintain the status quo. I want to say and let the legislature decide also. I want to say with the Alaska Supreme Court, when it abrogated contributory negligence and was urged to defer to the legislature, said that failing to act would represent judicial inertia rather than a reasoned consideration of the intrinsic value of the rule. That's Katz v. State. A reasoned consideration of the rule is what's needed here, and any reasoned consideration rejects the rule and replaces it with a comparative negligence regime. The government groups talk about the government liability in a carefully crafted statute. Well, it is a carefully crafted statute. This says nothing about the underlying causes of action to which it applies. It's only the waiver of state immunity. In the briefing on this, we addressed this, and the groups did present some empirical projections, and I think we've showed that even taking their empirical projections, one, the numbers would be very small, the monetary effect on state and local governments, and two, that what we're proposing here, if more people actually recovered under the State Tort Claims Act, that's consistent with the purposes of the Act, that people who are harmed by their sovereign are recompensed by their sovereign. It's consistent with the right of access to courts in the Constitution. It's that legislative waiver. And it's, as I say, that purpose, that's a good purpose. And again, the legislature can make any changes that it's speculated they might have made. It said that turning to the Maryland Chamber's presentation, Maryland Chamber says that the legislature could adopt one bill. Well, the Michigan court, when it abrogated contributory negligence, noted that the typical comparative negligence statute is a couple of sentences, and that what most legislatures have done is left the fashioning of collateral consequences to the courts, because these things happen in the courts. They affect what happens in the courts, and the courts, in fact, are better equipped than the legislature to do with these issues. The Chamber also paints a picture of doom and gloom that it supports neither in argument nor in its brief with any kind of empirical evidence of doom and gloom occurring. One thing it does say is that we need certainty, we might have chaos. Well, one person's chaos is another person's adjudication. I don't think there's chaos. You've heard that there will not be chaos. This would be a relatively simple change. And, in fact, it will bring certainty quite soon, quite quickly, and, more important, it will bring justice. Failure to act will perpetuate injustice, and that is not the job of this court. The job of this court is to do justice, in making this change will do that. Thank you, Your Honor.
Thank you, sir. Flaxen.
What evidence is there in the record that would support a duty owed by the association to Mr. Coleman?
Mr. Coleman's a business invitee. Mr. Coleman was invited by SAC as a specific and express instruction, an invitation to come and help with practice. There's no gray area. He's a business invitee, and I don't think that's in dispute. And as such, he's owed the highest level of duty by the land user, in this case, SAC.
Okay, and how is that duty circumscribed geographically?
In a Howard County versus Chain case, or Cheney case, Cheyne, you had a little girl who was a spectator, and this court decided that the scope of the invitation, once she's established as an invitee, the scope of the invitation is a fact question for the jury whether or not she exceeded the invitation. These facts brought out by Mr. Beiser today, these facts which we dispute, were argued extensively in front of the trial court, and Judge McCrone, on two occasions, the pretrial motion for summary judgment made immediately before trial started, and the motion for directed verdict at the conclusion of the plaintiff's case, ruled that there was a duty. So Mr. Taberzi asks you to affirm the trial court on the issue of duty. We agree. There was a duty. Judge McCrone found there was a duty. There is no precise formula in Maryland for what actually is a duty.
What was the duty in this case?
In this case, the duty was to use reasonable care. Are you asking me what?
Yeah, to do what?
To make sure that the equipment that they were using was safe. Mr. Beiser's...
Mr. Coleman was using the equipment.
I'm sorry, what?
Who other than Mr. Coleman was using this unnetted soccer goal?
Well, it was not unnetted. The soccer goal had a rebound net or a training net behind the goal. It was an unnetted net. And the facts by defendant's answers to interrogatories, by a statement by an independent witness made shortly after the, Robert Hess made shortly after the incident, and was that there was a net. There was a net right behind there. And then you have Coach Fox's testimony that whenever he would come upon this goal, when it was there at practice, he would use the goal. And that he knew that it was unanchored, and that he knew he shouldn't use the goal. And you have you have COO Carlin, the CEO executive officer of SAC, saying that the standard of care was to not use unanchored goals.
And not a SAC goal, though. Is that right?
No, but there's no distinction. If you tell a coach, don't use unanchored goals, I mean, just like when they come on, a lot has been made of the ownership of this goal. When you set up a field to play on, if there's a low-hanging branch, you don't avoid responsibility by saying we didn't own the tree. If there's glass or broken bottles on the field, you don't avoid responsibility by saying we didn't put the dangerous instrumentality or the sharp object on the field. And in this case, using dangerous equipment, knowingly using dangerous equipment, was a breach of that duty. And you don't escape that by simply saying we didn't bring that goal to the practice field. They had used that goal many times. Why would we think, in the facts that are laid out in this case, that on this night in question, this team wouldn't use a goal that they testified, in fact, was irresistible and that coaches love goals? I hope I answered your question, Judge Harrell. I do want to point out to the Court something. I'm in an unenviable position of rebutting an argument that I've not heard of yet, the cross appeal.
You've got a short time to do it.
So I do want to point out to this Court that SAC has not preserved the appeal. The Court has said that you have very precise rubrics with Maryland rules, and that the language that you use in terms of preserving appeal is that any party may move at the close of evidence offered by an opponent or at the close of all evidence. And in this case, no directed verdict was made at the close of evidence. The evidence closed. The court took a recess.
They indicate in their reply to that argument that the court reopened for that purpose.
Well, they didn't reopen evidence. There was a recess. There was an instruction given to the 20 or 30 minutes of jury instructions were given. The podium was set up, and it was time to give closing argument when defense counsel came up to the bench and said, I forgot to give the make that motion. So it was not at the conclusion of evidence. And if you allow a 1 hour or 2 hour delay, what next? After the jury deliberates or during jury deliberations? Your cases are very precise on when those motions are to be made, and it was not made at the conclusion of evidence. I have other issues I'd like to cover, but my time's up.
I know, but it's always... Thank you, sir.
Thank you.
Mr. Feasor.
Thank you, Your Honor. Your Honor, just addressing that last point first, the case was reopened. The motion, as allowed by the court, the motion was made on duty and denied, so it was preserved. What wasn't preserved for this court is the standard of care as a landowner, being a business invitee. Plaintiffs requested instructions on the duty of care as a landowner. Those instructions were not given by the court, and no exception was given to them. So for counsel to say that there was a duty as a business invitee is incorrect. It was not preserved for the appeal. I mean, it was not decided by the court nor preserved for the appeal. So that is not an issue here before the court. Just to answer the question of the court before, the judicial decisions, 8 switching from contrib to comparative, 8 were pure and 4 were modified. Judge Harrell, you asked about the legislative General Assembly not acting on things and what inferences can be inferred by that. This court in Moore v. State found that legislative inaction is strong evidence of intent. And I think that that's...
I have 6 other cases for you in 15 minutes. Make something else up.
Well, Your Honor, because of the number of bills that have been introduced and rejected for comparative, I think the intent is that the legislature deemed that comparative negligence is not suitable for the law and policy in Maryland. The other question that was asked, though, what are the implications in the other states that have gone to comparative? That's an excellent question, and that's going to take study, it's going to take hearings, it's going to take expert witnesses, it's going to take empirical analysis of all those things. The body to do those types of studies and take testimony is the General Assembly.
Wasn't there a fairly extensive study done in 2004 by the Department of Legislative Services about other jurisdictions, how they either adapted to or rejected that?
There was, Your Honor. I don't know how up to date that is, but there was. But that
what's changed since 2004 then? What other states have jumped on board or chosen not to jump on board since 2004?
I don't think any since 2004, Your Honor. With regard to the issue, my other issues on the subsequent remedial measures in this case, the question was asked, well, wasn't that the obligation or wasn't that the standard before? It was not. The 2008 administrative handbook that was prepared in December of 2008, this was an August accident, after this, instituted a new guideline for the coaches about goals on fields other than the SAC fields, which they had a couple fields on their own, but they had 300 rec teams, so you can imagine they were going out into these county fields. And that's why, this case is why they changed what they were doing before. This was not a rehash of what they had done before. And the trial court brought that, first of all, the use of the subsequent remedial measures was for the very purpose of the standard of care. The court asked Mr. Paxson, let me ask you this, Mr. Paxson, what would you be offering the 2008 manual to prove? Mr. Paxson, the standard of care, the duty to warn. And so Mr. Plaxton argued, well, this is just rehashing the old stuff. But then after Mr. Carlin, the director of SAC, actually testified, the court said, there was a representation by plaintiff's counsel that Mr. Carlin had indicated in his deposition, perhaps in answers to interrogatories, but clearly in the deposition, the safety policies that were, although the first time that they were written down was in the 2008 manual, but the same policies had been in effect previous to this particular accident. The testimony that's developed has been slightly different than that. I was affected by that representation. It's because his testimony wasn't that. His testimony was that the policy changed after this accident. There had been no policy instructing coaches to do anything with respect to Board of Education goals or whoever owned other goals at the time. And this was a change. But they hammered that. They used it in an opening statement. They used it during the cross-examination of every liability witness. And they hammered it to the jury in closing. Why? Because it was important. And it was their thread to liability of primary negligence. And that's why it's reversible error. The other reversible error that we raise and we argue is the admission of Mr. Barbie as an expert witness. Mr. Barbie was 80 years of age. He last played soccer 40 years prior to this case. His background was in industrial safety, had no education or training in soccer or sports other than 40 years before. He was never qualified as an expert in soccer safety. He's never been hired by a school or recreational facility to do any studies. He had never done any surveys of what the standard of care and duties are in any soccer facilities. His ASTM membership, which is the Society for Testing Materials, was only for product design. He wasn't on the subcommittee, even though he tried to represent that at first.
What's our standard of review for reviewing the judge's qualifications? The trial court has discretion, broad discretion in admitting experts. But this, it was an abuse of discretion. This man had nothing that he could offer to the jury that would help them, other than his personal opinion. And so, while it is a tough hurdle that I have on this, if you look at his testimony, this gentleman had no experience. He had less experience than most jurors who had played soccer within 40 years. You know, he is one of these experts who had been an expert in power saws and ladders and explosions and factory things, off-road safety, hygiene, jetways, but not in soccer. And so it was an abuse of discretion by the trial court to allow him to testify. Counsel have argued that this case is unfair. This was a kid. This was not a kid in this case. Coleman was 21 years old. He was an independent adult working and living on his own. And volunteered to come to this, to be the adult supervision. This is not an unfair result when he comes, he's high on marijuana and decides to swing, misusing a goal. Counsel calls the Harrison decision problematic. It's not problematic. It's the rule. It's the law in Maryland, authored by Judge Murphy, whose name hangs on the outside of this courthouse. It's the controlling law in this case. When you read Harrison, virtually every issue that has been presented today was decided by Judge Murphy and this court in the Harrison case. So it's not problematic to the extent that the law in Maryland is problematic. I would submit to Your Honor that the only difference between the law and the facts in our society in 1983 and now is the passage of some time in the makeup of this court. Our law is a law of decisions. It's not a law of men. The Harrison case was correctly decided. We should defer to that precedent and the stare decisis in keeping that law the same. Thank you.
Thank you all.
Unusual tree, huh?